You're watching Bloomberg Law. I'm Lee Pacquiao. As Dewey and LaBeouf imploded in recent weeks, many big firm lawyers have wondered, could my firm be next? Paul Lippi, the founder and CEO of OnRamp Systems, has your answer. He wrote a column for ABAjournal.com that provides a handy checklist for spotting the next big law firm on the verge of dissolution. Welcome. Thank you so much for coming in.
Thanks. I'm pretty sure I don't have any answers. I just laid out some questions.
Just questions, and that's all I have, unfortunately.
That's all any
so
of
this
us
should be interesting.
Right
on. So your checklist had 12 items. We can't get to all of them, unfortunately. But let's start with number 4. I found that particularly interesting.
Okay.
Do mergers and acquisitions advance the strategy? You said firms should ask themselves before they kind of go into a merger, what they'll tell their clients once the transaction is completed. Could you explain that for us?
Sure. Just a little background. I was a general counsel of a public company in Silicon Valley for a long time, and like a lot of other people in that role, I actually ran business development. So we studied very intensively what worked and what didn't work in mergers. And depending on what source you cite, and McKinsey is the most frequently cited source, 60% of mergers fail. Whether it's Dewey merging with LaBeouf or it's hiring a lateral partner.
These are legal mergers, or 60% of mergers in general
In
fail?
the general. I don't think anybody's ever studied the legal industry. Right. So if 60% of mergers among companies that have relatively sophisticated management cultures fail, one has to assume that there's a proportionate failure rate in the legal world. Whether it's merging Dewey with LaBeouf or hiring a lateral, those are both forms of M&A. Not to say that they can't work, but to sort of put up a couple of PowerPoint and say 1 + 1 = 3, that's not especially rigorous. So you've actually got to put yourself through some very rigorous tests, both in evaluating the merger and executing the merger. I think the test I suggested in the article was the test that one of the tests that we came up with, which all we did was crib it from Intel or Cisco or somebody else, which was, what do I tell, in our case, the customer, in law firm's case, the client, the morning after the deal is announced on why they're better off. And if all the law firm can say is, you used to buy your capital markets expertise from Dewey, and now you can buy your energy regulatory expertise from Dewey LaBeouf, I'm not sure that's compelling to the client, and I'm not sure you could actually find very many clients who would say that style of merger delivers superior value.
And a lot of people are saying that it was the merger in large part that led to the demise of Dewey and LaBeouf. I guess you would agree with some of those.
I think you've got it. They did presumably they did the merger because of the way they understood their opportunities and problems. So it could have been a Hail Mary for all we know. I wouldn't say it was the cause. I just think mergers in general are hard to pull off. And if you're not really rigorous about it, and in particular, if you're not focused on integrating value and delivering superior value to the client, the likelihood you're going to create value through a merger is very low.
Let's move on to number 7. Does compensation make enough sense that can be defended? What's your take on firms like Dewey, where there was a compensation spread amongst partners that was something like 20-1?
So this is, this isn't my field. Clearly, most people who've written about it have remarked that there's a very high level of spread. Personally, I'm probably somewhat more comfortable with a high level of spread than a lot of people. But the minimum litmus test you would take is, can you explain it, right? So if Derek Jeter's making X and the backup shortstop's making 1/15th X, people can understand that and it's defensible. If management is systematically not sharing information, especially in a partnership culture where people expect to have the information, that's probably a pretty good sign that, in fact, the compensation decisions are problematic in some way. Right?
Item number 10, does the firm listen to critics? What do you mean by that?
Well, I think in any organization, you're going to have a certain, so if you're the head of the organization, you can't listen to every negative thing, right? You can't deal with all the noise. You can't solve every problem. So whether a healthy organization or an imperfectly healthy organization, there's got to be a bias to optimism, and that's appropriate, right? But by the same token, the world is full of what we might call anomalies. There are events that occur that don't coincide with your model, but you need to understand them, right? If you're the New York Times, you need to understand what the rise of Craigslist or Google potentially means for your business and take that on board. what I think happened in the Dewey case, and I certainly, again, don't purport to be an expert on all the ins and outs, a couple of people, Bruce McEwen among them, wrote things that were critical, and Bruce is a very smart guy. Bruce is a very savvy guy. From what I've seen, his stuff held up rock solid. But some of the Dewey folks basically, sort of blame the bloggers, and I don't think Bruce is a blogger. I think he's very sophisticated. So whether their response was a natural reaction to being criticized or reflected the fact that they actually didn't understand that Bruce understood what was going on there at a very high level, no one can know. But you ought to at least, if somebody's saying, hey, you need to do something different, you ought to take it on board. And I think you'd find, anybody from Peter Drucker to the Dalai Lama would tell you that, right? It's leadership 101 level stuff.
The last item on your list was really interesting. Does the firm experiment with at least 5% of its work? It sounds a bit like Google, where they encourage their engineers to spend 20% of their time on side projects.
Back,
oh, it's lower now?
I think so.
It's the new normal over there.
The new normal is a moving target, for sure.
But law firms are very different from internet companies. Is that something that a law firm can pull off, especially when they have clients? I mean, is a law firm's clients going to be happy with attorneys spending 5% of their time experimenting or trying to figure out how to innovate?
Oh, well, I mean, I think the clients will be thrilled if they spent 5% of their time in collaborative, engaged efforts with and I think, frankly, most of them do, sit down with a client and say, how could we do things more efficiently? How could we do things higher quality? How could we do things better? I think look, law is not fully a profession. It's not fully a commercial venture. It's kind of has characteristics of both. And that can be a good thing, but it also can be a problematic thing. If I'm a commercial venture, if you read the New Yorker 2 weeks ago, John Hennessy's a pretty smart dude. He's the president of Stanford. He said, we're living in an age of disruption. Things are happening that exceed our expectation or capacity to easily manage change. If your response to that is denial, to constantly say, oh, that's an aberration, I don't have to deal with that, that's some wacky thing out there, then you shut yourself off from the possibility of learning and improvement, and that would be a very unhealthy behavior for a profession to take on. On the other hand, if you say, look, why wouldn't we do some of our work on a fixed fee? Why wouldn't we experiment with shared teams and project management and process re-engineering? Seyfarth is doing it. Bartlett Beck does it. It's not like these are alien ideas. And I think if Mr. Dewey himself, Governor Dewey, were here, he would recognize what we might refer to as a new normal as being a very old normal, right? So I think law was in a boom for 15 years, from 1992 to 2007. And like any industry in a boom, it sort of expects that that's the natural state of the universe.
Sure.
But it might not be the only natural state of the universe.
So leaving the last item on your checklist aside, how many law firms in your estimation, or at least big law firms, meet this test?
Would be able to say yes to all 12 questions? Well, the good news...
avoid Dewey's fate.
Oh, I think most of them will obviously avoid Dewey's fate. I mean, look, the law firm model is a very resilient model, right? And Dewey clearly made more than their fair share of mistakes. I don't imagine that they were ill-intentioned in any way, but they got themselves into a context where they made some mistakes. I think the questions are just, they're just common sense questions. It's not Fermat's last theorem there. So I think the real test would be, are we at least asking the questions? And 12 months from now, can we say yes to one or two more than we could today? And 12 months after that, another one or two. As long as you're engaged in trying to improve, you're fine. If you imagine you've reached the end state of human development and you're the perfect organization and nothing could ever be better, that's usually a pretty good predictor of coming catastrophe, right?
Your column is called The New Normal, and it's devoted to the idea that the legal profession is changing in fundamental ways. Do you really believe that in 5 years, the very nature of big law practice is going to look entirely different from the way it does today?
Yeah, I don't. This is a curiosity to me. I don't think it's a change, and that part of that's why we chose the term new normal. I think most of the things that we're identifying are recapturing the best values of the firms from, perhaps their golden era, the 50s through the 70s. So I don't see any of these things as particularly radical. And I think if you talk to someone like Fred Bartlett or any successful lawyer who both founded a firm and runs a firm today, they would check down that list and say, yeah, we're all 12 of 12. I think if you could connect to Governor Dewey or people who founded the firms 100 years ago, they would say, yep, we're 10 or 11 of 12. They may not recognize
but those entities are totally different from what we're dealing with today. I mean,
but then don't suggest that my view is the radical view. It's the firms have taken themselves in a direction which made sense and made sense in a context, but as the context changes, they have to find the right change. And I think most of them will. They're smart, rational people, and law firms are very federated organizations. So somebody over here can try something. If it works, somebody over here do it. So I think, but there is this sense, which you and I were talking about earlier, which I really don't understand. So Skadden, there was a world. I'm 54 years old. There was a world in which people who worked at Skadden couldn't get a job at other quote-unquote white shoe firms because of their last name. That was the world that people thought was fixed and immutable in 1963. That world is gone. The whole history of our lives is a series of changes that people thought would never happen. Watch Mad Men on TV. All the behaviors there would be unimaginable today. And if you'd ask somebody, will you get to a workplace where you don't have that kind of sexism and people smoking all the time? They would have said, of course not. It's a natural state of the universe. But it isn't. Things change.
Oh, that's life. Paul, thanks so much for coming in.
Thank you very much.
That's Paul Lippi, CEO of Legal On-Ramp. If you'd like to learn more about the issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can check on our updates on Twitter. I'm Lee Pacquiao. Thanks for watching.